I agree. It's a probable cause hearing. I think the officer's testimony about what she was told at the scene by the alleged victim is enough to bind it over. So I will bind over on count one, and as we've all said, everything else just tags along. AOI date's going to be the 30th, 9 a.m. Anything as to bond, gentlemen, or should it stay the same? All right, appearances on the People versus Mullis.
Oh, sorry. You guys,
Mullis.
Judge, is this in regards to the malicious destruction of personal property? She has.
Sure.
I'm only on two of them. Mohammed on behalf of the people, in regards to the malicious destruction of personal property as well as the DWLS case.
And good morning to your honor court staff, Jonathan Roberts, P 86428. On behalf of Mr. Mullis, asked two files ending in 0407-SM and 0406-ST, which are being covered by Mr. Mohammed. Mr. Mullis, can you please state your name for me?
Thank you. You can have a seat, sir.
Judge, in regards to the DWLS account for case, I'm moving for a nolle process in the interest of justice. It's my understanding the city had prosecuted on that case already, so there appears to be some potential double jeopardy issues.
Okay.
So in the interest of justice, I'm moving to dismiss that case.
No objection?
Without objection.
Thank you.
In
As
regards to the malicious destruction of the property case, Judge, the pleading witness was subpoenaed to be here. She's failed to appear. The officer did make attempts to serve the complaining witness in this case with her subpoena. He informed me that on 6/17, he attempted to serve her in person. On 6/18, he left voicemails on Friday, and on Friday morning, he sent an email with a subpoena explaining that her attendance was needed for this case to move forward. There was no response. So based on that, people are unable to proceed.
thank you, Mr. Roberts.
On that basis, Judge, dismiss without prejudice.
Granted. All right, thank you, Mr. Mohammed. All right, Mr. Lecky, now your appearance.
Your Honor, Jake, I'm appearing on behalf of the people, PA 000.
And again, good morning to your honor court staff, Roberts, P 86428. Representing Mr. Mullis, on file ending 0453-FY. Mr. Mullis is to my left. You can take the vote.
Thank you. Have a seat, Mr. Mullis. Are we ready to get started, guys?
Yeah, for the record, I believe Mr. Lecky is intending to add certain charges that was like those to be noticed prior to the exam.
Yes, Your Honor. So at this time, the people are looking to add the failure to stop after collision. I don't have the MCLs right now. I'm sorry. And the license plate, registration, title, and lawful use. Like I said, I can look at the MCLs.
Okay,
But they are misdemeanors. However, I think testimony is going to come out today. Those were permitted.
okay. All right, ready to get started on the exam?
Ready.
Let's call a witness.
But this time, we are going to ask that officer. Had a hold of the stand.
Officer, come on up.
Officer, really good. Small. Here, I'm going to ask for a mutual order of sequestration. Thanks.
Okay, granted. Raise your right hand. Swear or affirm to tell the truth, the whole truth, nothing but the truth today. Come on up here, watch your step on my ramp, settle in that chair. Holcomb, HOLC. When you're ready.
Yes, and before we begin, we are going to be offering evidence under MCL 76827C. Is the hearsay exception that allows domestic violence incidents to come in. We see that it being entered in through this witness. I believe her testimony will reflect that all the elements max to allow that exception.
All right. Proceed.
Okay. Good morning, Officer. How are you employed?
With the city of Belleville
As what?
as a police officer.
Okay, if you could, I'm not gonna difficult hearing a few things. Yes, perfect. And how long were you employed in that capacity?
The city of Belleville, approximately a year. Overall,
Yes, either.
overall 19 years as a
Okay.
police officer.
And what do you do as a part of your duties as an officer in the city of Belleville?
Routine patrol, which was check stops, responding to police runs, traffic accidents, things of that nature.
And did you respond to a police run at a 213 Aberdeen Port in Belleville, Michigan on June 1st, 2026?
Yes.
And was that, and what time of day was that?
It was in the evening, it was 21:30.
Judge, for the record, I believe Officer Holcomb is reading from the report. I just want that to be shown for the record.
Yes.
Noted.
Point to- no,
Go ahead.
So. Now that your record is placed face down in front of you, what time did you arrive for it?
We were dispatched, I was at the location within 30 seconds of dispatch.
And Judge, if we could get clarification, you said B, so who was your reply to?
Fair enough.
Officer Pearl.
Okay. And yourself, correct? Okay. So. You both arrived at that location, what did you see when you looked?
On my arrival, I saw some reverse lights coming out of the driveway of the location.
Okay, of what do you know what vehicle was?
It was a Chevy Equinox.
Okay, and did you at any time stop that vehicle?
I activated my overhead lights, and gave verbal commands for the defendant to pull back away from the driveway.
Okay, so you say defendant, who is that?
Cody Wallace,
Okay, is that person? And this is the individual that you saw, right?
Objection to leading, Judge.
Sounded like it. Rephrase.
And is. And this individual, who is that? Who's the driver?
the driver of the vehicle was Cody Wallace.
Okay, and that is the person,
Objection leading.
and is that person in the court?
Yes,
Okay, can you point them out, they know that,
yes, he's directly behind him, jumps.
Noted.
thank you. So at this time, Cody Moss, that is the person that you stated earlier was the defendant, is that?
Correct.
Okay, so. Now. What do you see? That vehicle do?
Reversing out of the driveway.
Does it do anything else?
Came very close to striking my car, but swerved to miss my car.
So and when did that happen?
Upon my arrival,
Yes, how shortly after?
immediately.
Okay. So just for clarification. You are arriving to this residence, you see this vehicle back out, and then you actually go, is that?
Correct.
Okay, what happens?
What the next you said?
Yeah.
Mr. Mullins follows my commands and pulls back into the car.
Okay, so down the street and then goes back into the car.
Correct.
You notice anything,
Well, Judge, advocate, I've got this clarification of the testimony. She never said that he was in the street. She said that he was still in the driveway, so I asked if that portion be stricken.
I asked if she was pulled over in the street, she said yes.
Clarify with some follow-up questions.
So what did you see this car do? I want you to explain every single detail you saw this car do.
So I see the backup lights as I bend the corner to get to the location. I, at that point, speed up because I anticipate him attempting to flee. When I get there, I activate my lights. He's still
Where's there?
the 213 Hevery.
Okay, keep going.
I'm in front of the driveway, I activate my lights. He's still reversing, swerves to miss my car and enters into the roadway.
Okay. Then what?
I give verbal command to return to the driveway and he follows those verbal commands.
Okay. Then what?
Then, Officer Pro pulls up at that time and we attempt to separate the parties, Jennifer and Cody, to figure out what is happening.
Okay, so at the time this car pulls into the driveway, there is another individual there. You identify, is that correct? Okay, and who did you say that was?
Jennifer DeBoer,
Okay, and where was she at?
she was also in the group. On both.
What happened after that?
I then spoke with Jennifer and my partner spoke to Cody.
Now, in your conversation with Jennifer, how long after the call was that?
A minute or two.
Okay. And what did she indicate to you?
And I would object this. That's your second.
So this is the hearsay that we're getting in under 27C. It is a instance of domestic violence. It was shortly after this officer has indicated, court will hear it, that it is an instance of domestic violence, so it comes in our desk.
Anything else, Mr. Roberts?
What went that?
Go ahead.
So what did that individual indicate to you?
She indicated that she had invited Cody over to speak in public service.
Okay, I'm gonna
Also, know that there was an active PBO in that at the time of this. She said that the conversation turned into an argument. She asked Cody to leave. She said if you can call 911, and she said that Cody said if she called 911, he was going to kill her. She said that they had a struggle. He put her against his car, making car parts fall off of his car and tearing her shirt, and bruising her. She said that at that point she tried to call 911 again. Cody slapped the bone out of her.
So I want to stop you. So I see her looking at something.
I mean,
So I've seen what exactly she stated to you. Do you remember off the top of your head?
well, this is my police report that I did,
That wasn't the question. The question is, do you remember?
but not 100%.
Okay, so are you referring to something to,
And Judge, I'll renew my objection, so the issue here is that the statement needs to be reliable, and if she's reading from the report, I think she just testified that this is really good to read from the report, which is right next to her record. There's asked for clarity as to whether or not she can remember, and now it's, I can, but not 100%. We're straining the purpose of this rule, which is to allow for reliable testimony. I just want to read my objection to hearsay because I don't think this is following what it's going to see at this point.
Mr. Leckie?
yeah, I was in the middle of trying to get there, but I was interrupted during the questions, but I still see your
Try.
any additional information. So you can explicitly remember word for word at this moment what she said.
There's a sequence of events. I don't want to misquote this.
Well, just answer my question. No,
Question.
can you explicitly right now remember word for word exactly what she said? Okay, but on that day and that time, you did have a conversation.
Correct.
You did detail that in the police report, correct? Okay, now is that police report what you had from? Now, if you had to, you could remember that conversation, correct?
Objection, Judge, that's speculation and it's legal.
Could you remember a conversation based on it? So, how this procedure works is if I ask you a question of what she said next, if you say, I don't remember, then we have to go through is there something that would help you remember that conversation? So is there something that would help you remember that conversation? Okay, and what is that? Okay, so take a minute, look over that. And then, once you have, flip it over, and then we'll start this from the beginning, if that's fair. There are the objections.
I don't know if it's been ruling, but I'll let her.
I'm allowing it.
So you flipped your police report, there you go. Take your memory refreshes to your conversation with that victim that day that happened. Okay, and what did she tell you? Let's start back from the beginning, okay? So what did she say to you?
She said when she invited Cody over to the conversation regarding Wisconsin.
Okay, and then what?
She stated that after it turned into an argument, she asked Cody to leave. As she was asking Cody to leave, they entered out in the garage from the home. She said Cody pinned her against his vehicle, causing damage to his vehicle and bruising on her. She stated that she was unable to break free from that, and he pinned her against the storm door in the garage and put his arm around her neck, choking her.
Okay, and what else did she describe?
When I asked her on a scale of 1 to 10, her level of choking, she said it was 10. She couldn't breathe, and she believed that he was going to kill her.
And what else?
Stated that lasted for approximately 15 seconds.
Anything else?
After that, she said she tried to call 911, and he slapped the phone out of her hand. She yelled in the house for her daughter to call 911. Daughter came out, he released any grip from her, and she stopped and called 911.
Anything else, sir?
After she called 911, she said that he realized she called 911, and that's when he got his vehicle to police.
And that's where you see him next.
Correct.
Okay. Do you see anything stand out about? So you talked to her. Did you look at the car that punched?
Yes.
What stood out to you about that car?
There was a mark on the rear passenger bumper or panel area consistent with,
Objection, that I think that's going with speculation, she just, her observation.
Okay.
Fair enough.
What did you observe?
I saw vehicle damage on the property.
Okay. And did you see anything else of any, what else did you see?
I saw vehicle damage on a Jeep that's parked in the driveway.
Oh. And can you describe the damage?
There was paint transfer on both cars. Consistent with possible collision.
Okay.
So that was speculation, so the collision piece,
Any response to speculation objection?
Fine.
Move on.
So you saw paint marks on both cars, is that right? So one car was what? The Jeep was what color?
Jeep was black.
Okay, and what paint trade did you see on that car?
I saw silver paint on the Jeep,
Okay, and what car did you say the defendant was driving?
a silver Equinox.
Okay, and so that car was silver, as you just said,
Correct.
what color paint is on there? Okay, and was there anything else around that scene that you noticed?
There was broken parts from his vehicle in the garage from when he entered.
Objection, just as speculation, that.
So,
It is.
without speculating, what, you can only testify to what you're.
Garage.
And okay, now, this is just you. What did you do next with that information you okay?
I advised the department that Cody was arrested for these.
Okay, and then did you arrest? Now, when you arrest him, do you look up he was driving, is that right?
Yes.
Okay, Did you look up anything about his car?
Member did not.
Okay, so your partner, Officer Brooks, then. Did you look up his? And does that include his registration status and all of that? Yeah. And you saw those car parts, did you see even? Did you see anything else besides his vehicle reverse?
Upon my arrival, I observed the reverse lights. And I saw the reverse lights go off and him pull forward. And then him start re-reversing, and that was when I was directly behind.
Okay, so, and him being the defendant, so you saw the defendant's car's reverse lights go on.
Yes.
Then go forward. Then it changed and went back again. Okay. Your Honor, I'm looking for.
Mr. Roberts, your witness.
Good. All staff, Judge and Officer Holcomb, how are you doing? Great, thank you. Now, have you ever interacted with Mr. Wallace before? And that was during your time as a Bellevue police officer? You've also interacted with Jennifer before? And for this case, you're saying you had that conversation with Jennifer the day of the incident, fair to say? So of course, as often charged, you wanted to make sure that Jennifer could testify if she was willing to, correct? And as part of that, there were subpoenas sent to Jennifer.
I did forward her via.
You also know that there are other cases involving Cody Wallace and Jennifer, correct? And there have been attempts to serve her with subpoenas for those, correct? You're aware that at least for the more contemporaneous cases, she was attempted service on June 17th, is that correct?
That's what I just said.
As well as June 18th.
That's what I just said.
Well, Your Honor, that's hearsay.
Oh, she doesn't know this. I don't mind it. If you don't know, you can just say you don't.
I just heard it in the previous,
Okay.
Understood.
So I asked to be strict.
Stricken.
So with respect to your subpoena efforts, did you make any contact with Jennifer after that day? Okay. Did you attempt to go to her house?
I think the next day. But I've been out of town for the last 10 days, so.
So I'm assuming you kind of delegated that to somebody else.
I forwarded her subpoena. I should, and Sunday, Monday.
Okay. Any other contact that you had with Jennifer since that evening?
One day after. I was followed.
Now, as part of this case, because it's domestic violence, you typically prepare a domestic violence report, correct?
Yes.
And that is to document your observations on the scene there, as well as document any injuries that you see on a victim, correct? And the importance of that is to make sure that even if we're dealing with the case from months away, years away, you can remember what was fresh in your mind, correct?
Yes.
And for any of those reports, you'd agree with me that you want to be extremely detailed and you want to be accurate. You prepared one of those for this case, correct?
Yes.
And I just want to go over what you noted in that report. It's fair to say, in that report, you denied that there was a PPO against Mr. Wallace, fair?
I'm not sure. I believe there was an active PPO at the time of this.
So my question is a little different. In your domestic violence incident report, it's fair to say you denied that there was a PPO against Mr. Wallace, correct? When reviewing the domestic violence incident report, refresh your recollection. Your Honor, opposing counsel witness in turn, report will be marked with Defense A for identification purposes. Page, that's so happy. Can you see the screen, officer?
Yes.
Can you tell us what this is? Is this the
Speak up, counsel, or officer. Thank you.
This is the report you prepared for the incident involving Cody Mullis and Jennifer on the date that you stated?
Yes.
Just want to review it. If you can, let me know when your memories refresh.
See that? That was probably accidental.
So to answer my question, in the report that you stated clearly has to be accurate, has to be detailed, you put that there was no appeal against Mr. Mullis, correct?
In that domestic violence report, correct. In the incident report,
So my question is stuff that the message report. Thank you, officer. You also made notations as to injuries, correct?
yes.
And the helpful thing about these incident reports is that there's actually a figurine where you can mark injuries, correct? And you're expected to mark injuries on the figurine so that we have a detailed understanding of what injuries were fresh from the incident, fair to say? On your domestic violence incident report, you make no notations of injuries on the figurine, is that correct?
I don't have that yet.
Would reviewing again refresh the recollection. Permission to approach again. Thank you. With defense A for the record. And just let me know when you're ready.
Okay.
So I'll ask again, officer, on the incident report, which is supposed to be both detailed and accurate, you don't make any notations as to injuries on the figurine, correct? There's also a place where you can indicate whether there was strangulation, correct? Like checkboxing, you're not sure? Would reviewing refresh? Is that yes?
Okay.
Approaching with defense A. Let me know when you're ready.
Yes.
So there is a place where you can mark whether you saw signs of strangulation, correct? You did not mark that there were signs of strangulation in your incident report, correct? What you do know in your incident report is that you have somewhat of a problem with Mr. Mullis.
No.
Well, you specifically know that Mr. Mullis has arrest for domestic violence, but he doesn't have any convictions. So Jennifer is not here today, correct?
Right.
To the best of your knowledge, she hasn't communicated to you about the case.
Right.
You're still testifying about that incident, fair? A moment. Nothing further, either. Thank you.
Mr. Lecky, officer, you can step down. Watch your step on that ramp. Mr. Lecky, before you call the next witness, are you going to call another witness? Let me take care of a plea. Mr. Duncan on Ibrahim.
Well, Judge Murray Duncan appearing on behalf of the defendant.
Good morning.
We've had in this far, today, the date and time set for bench trial, there's been an agreement that my client can plead guilty to allowing An unlicensed person operating motor vehicle and to impeding traffic, infraction would be dismissed and the driving as suspected would be dismissed.
Thank you. Any objection if I just process one file, just dismiss the civil infraction outright and just hit him a little harder with the money on the misdemeanor? Just less work for Heather. All right, Mr. Abraham, do you understand your rights?
Yes, I do, Your Honor.
Understand the options those rights give you today?
Yes, Your Honor.
You understand the possible penalty for the added charge of allow unlicensed driver to operate?
Yes.
Understanding all of that, are you pleading guilty to that charge today freely and voluntarily?
That is correct.
Sir, did you operate a vehicle on March 9, 2026 at a location near Harrison and Cherry in the city of Romulus? At that time, was your license suspended, revoked, or denied? Counsel satisfied?
Yes.
I'll accept the plea to the added charge, dismiss both the original charges. What should I know about Mr. Ibrahim before I sentence him?
Yes, that would be great today because he's eligible to have hearing, but obviously if he's put it on his record, he wouldn't be happy.
Yeah.
So he's gonna retain me now. We're gonna go ahead and.
Good. Good luck with your license.
Thank you.
All right, you working?
Yes.
Where at? How long?
Three months.
Okay. Anything else you want me to consider before I sentence?
Move forward, be more responsible with my actions and do the right thing, to go about the right process, to do what I need to do, Your Honor.
All right. You don't have a hearing date yet,
No, I had to wait and see what happens.
Yeah. but he's eligible.
He don't.
Okay. What, just curiosity, time frame? How long will it take you to get in front of somebody?
Gonna get a substance abuse evaluation, so that's gonna take probably about.
Yeah.
3 weeks.
Yeah.
3 to 6 notarized letters.
Mhm.
And he's gonna fill out a form, I turn that in, and when I do turn that in, sometimes I get a hearing in 4 to 5 weeks, sometimes it's 12 weeks, it just, I think depends on how busy.
How they fall.
There's 10 hearing officers.
Okay. All right. All right, I will do fines and costs, $750, and I'm ordering 4 days on the court work program as an alternative to jail. You pick which days you want to work. We're currently scheduling Monday through Saturday. Can you pay the $750? How much is bond money in that one? Okay, so the civil infraction's already got $230 on it. We'll apply that to the $750. Can you pay the balance today or do you need options? All right, pay that today and schedule your work days. Any questions?
No.
All right, good luck with your license.
Thank you.
Sure.
I was just gonna let you know, I visited
Good to see you.
Thank you, Your Honor.
You're welcome, sir. You want to tell Jacob I'm ready to go? Mr. Lecky, who's your next witness? Come on up, Officer Pearl.
Okay, well,
Chance for stipulation? Just hang out right there.
so stipulation to invalid license. That the license plate he was using was not his, it was from a Ford F-150. The license plate on this vehicle was a license plate to a Ford F-150, not.
And he wasn't driving an F-150.
And that his license plate registration and insurance were all invalid.
Solely for the purpose of exam, I don't want to say stipulate because still proves, but I would not object to those being part of the find over argument, and I will not make objections as to those being.
Is that helpful? Put him on.
That's,
Your call.
Your Honor, for bond or as to the additional counts 2 and 3 of the judge sheet.
Okay, we don't need you. Okay. All right, so no other defense or no other prosecution witnesses, correct? Defense putting any witnesses on? I'm ready for argument, guys.
One, which is all we're here for the exam today.
Yep.
We testified from a officer who heard from the victim of the victim. As we heard testimony, that statement wasn't domestic violence or a summary of a domestic violence incident of a threat or physical force. It was made in a timely manner, so it is credibility. It is credible. I believe she indicated that she was strangled. It was a rating of how strong the strangulation was, from 1 to 10 to the 10. She didn't say she didn't be pretty. Therefore, I think count 1 we consider the other reasonable doubt, at least for the purpose of the exam. Now, count 2 and count 3 we just follow. For the additional count 4, the failure to resist collision, we heard testimony that there was some broken car parts and there were some paint trading. The officer did describe that the defendant's car moved forward and then moved backwards. Moving forward was the car in the garage that was hit. And he failed to stop after that collision, instead driving away until he was stopped by the officer. Once he got into the roadway, but for the officer showing up, would have driven away. And by driving and backing away and getting into the street, I'm going to argue that he did drive away after that collision. Now, for failure to stop after a collision, it doesn't have to be at a highway. It can be in a personal place or a residence. So we're alleging that the collision happened in the driveway, in the garage. That jerk motion was him hitting the car, realizing that he wasn't driving. He then backed out and took off. But before the officer showed up, he would have been. Now, we also stipulated to the license plate that was on his vehicle, that he did display on his, whatever the vehicle type, but
Equinox.
the was belonging to a Ford F-150. That is the license plate registration title. It was a license plate not made or not for his vehicle that was fixed to his. Therefore, I think it would bind over on those 2 additional.
Thank you, Judge. With respect to count 1, there has been no credible evidence of strangulation, Judge. This officer indicated that shortly after this incident, she prepared a domestic violence incident report where she's supposed to document injuries that she sees, signs of strangulation. Strangulation is so common, Judge, that we make it part of the name of the GBH statute. Officers are trained to recognize those signs, certainly to take a narrative, which she did, but to recognize those signs. She states very clearly, she made no notations as to injuries observed at all on the body. If someone's being strangled for 15 seconds at a 10, Judge, there's going to be bruising at a minimum. We didn't hear any indications that there was loss of consciousness, difficulty breathing that she observed, and she arrives 30 seconds after this is supposed to have happened. So it's not just shortly after, it's basically immediately after. To see no injuries, to not notate that there's any indication of strangulation, there is not even at the probable cause level enough for strangulation. Her narrative will maintain our objection as hearsay. But with respect to count 2, which is domestic violence, Judge, if Your Honor chooses to credit the narrative of this officer, sure, there's enough for domestic violence. I mean, I'm not going to make a useless argument, but I think really the misdemeanor counts are what remain here, Judge. If there's strangulation, there will be signs, and this officer, I think, is obligated to notate those if there is some sign of that. And Jennifer's not here to give her side of the story, which I think should also be considered with respect to the reliability of that narrative. There were at least some attempts for a subpoena. She's not here. I won't speak out of the record as to other subpoena attempts, but for this case, she was subpoenaed. And You know, they have to show some proof of strangulation. And if it's not through Jennifer being here to say what injury she had, it would have to be through this officer observing something. And there isn't that, so for that reason, Judge, we're asking that count one be dismissed. If your honor credits our hearsay objection and ask that count two be dismissed, otherwise, I think the rest is misdemeanors and would be settled here.
Thank you. Ms. Relecki.
Mr. Honor, so I think it's important also that most of us know versus don't show up immediately, and they don't, multiple blues differently. I'm sure we've heard multiple testimonies throughout our years doing entirety that everyone was, so I don't think we can consider that. Also, there's no requirement by the statute that there has to be signed and proof, there has to be signed an injury. It just has to be that the mode was done by strangulation or suffocation, and that being assault. And we heard testimony that it was for about 15 seconds, and it was, she had a mercury. Your Honor, I think we could matter of by the word.
I agree. It's a probable cause hearing. I think the officer's testimony about what she was told at the scene by the alleged victim is enough to bind it over. So I will bind over on count one, and as we've all said, everything else just tags along. AOI date's going to be the 30th, 9 a.m. Anything as to bond, gentlemen, or should it stay the same?
Well, I guess.
No change to laws.
Bond will be continued, and Mr. Mullis, good luck downtown. Oh, Mr. Mullis, just to let you know, I know you're not in a position to do it right now, but you owe us $1,000 plus on various things. We're gonna need some kind of payment plan at some point. And I just made, I didn't do the statute, I just made it. Yeah.
Thank you, Judge. Thank you, Madam.
Hey, Mohammed. While you're out there, would you tell the attorneys on Lemke I'm ready to go? Thank you. Have a nice day. That's yours, Jacob? Stay safe.
That was my service here.
In this courtroom, the judge carefully listened to every detail before reaching a decision. The court showed patience, fairness, and respect for both sides, while ensuring that accountability remained at the center of justice. The judge's words reflected the importance of responsibility, self-control, and respect for others. Rather than acting on emotion, the court relied on facts, evidence, and the rule of law. This case serves as a reminder that justice is not only about punishment, but also about protecting victims, encouraging accountability, and maintaining public trust. The courtroom once again demonstrated why fairness and law matter in society.
A courtroom hearing took a tense turn when repeated interruptions pushed the judge to his limit. As attorneys argued over a taser threat case between neighbors, distractions continued from the gallery. The judge suddenly stopped the proceeding